Does Article 368, Part 20 give an absolute and ultimate power to parliamentary system to make any amendment in any provision of constitution? Can they amend the fundamental rights? Can they make changes into the fundamental rights of the citizens? Hello and welcome to another episode of Growth and Development. Today we'll be discussing about a very famous historical judgment by the Supreme Court on 24th April 1973, as we are celebrating the golden jubilee of Kesavananda Bharati case. Why this case is so important from the individual citizens of India's perspective? Because it has covered a lot of the fundamental rights, right to property, uh, and the land acquisition and all that stuff, it has made a history. And not only the history, post this judgment of 1973 24th April Kesavananda Bharati case, the preamble of the constitution, which says that we the people, having solemnly resolved to constitute a republic, socialist, democratic, for the country of the India, and we stand for the justice, liberty, fraternity, and equality for this nation. Before this Kesavananda Bharati case, this preamble was an idle to open the constitution, but later on it became the core component of the constitution: supremacy of the law, fundamental rights, right to freedom to the religion. All these factors were discussed. I mean, the provisions were discussed under 13 bench judgment by the Supreme Court. But before we get into this about the historical judgment, what was this case all about? It is very important to understand when the British left India in a condition when there was a poverty, inequality in terms of land, in terms of economic living standard, everything was unequal. There was no balance. Economically, we were left at the 3% GDP. We were, decentralized, destructured. Nothing was stabilized. So the first and foremost thing was to stable the country, stable the government and citizen into a state where we can look beyond and think about our future. So that was very important. So in that process, first of all, there took all along 3 and 4 years to make a constitution. What is constitution? Is certain laws to run a country, a written document of several articles, 395 articles and 13 chapters. But later on, several amendments were done in the constitution. And as per Dr. B.R. Ambedkar, the constitution has to be a living organism. Why he called the constitution living organism? Because in a country where we have diversity, and not only diversities in terms of religion, caste and region, we have so much diversities in terms of climatic conditions also. So the constitution can be amended, and there were lots of debates happened post independence that how the constitution should be created, made upon what grounds. Shall it be a rigid one which will not require any kind of changes, or should be a flexible constitution which can be amended with certain approvals of parliament, with majority and the president's approval or not. So there were lots of debate happened. Few people, 90% people, were in favor of flexibility to make changes, to make an amendments in the constitutions, and few people were against it. But in 1949 on 20th November, it somehow came into existence, and in 1950 26th January, it get into a operational state. But at that point of time, as I said earlier, India was struggling with poverty and several other issues which were very challenging for the for the democratic country. So in order to uplift certain section of the country, it was necessary to make an amendment, necessary to make certain changes in terms of land acquisition and all that stuff. So Kerala state of Kerala, came up with an act of land acquisition, land reform act, in which they wanted to have an equality in terms of acquiring the land. They wanted to have an equality for zamindar and all those stuff, the landowners, that these this much land you can acquire as per the law. In doing so, there were certain things happen when the Admir Mutt land was acquired in 1960, and it became a very challenging situation for that Mutt, to run its daily practices. They were dependent upon the lands and the wealth. So the head of this land, this portion, this premises, went against the law, went against this, Land Acquisition Act, Land Reform Act of Kerala government into the Supreme Court. There he challenged two questions, two basic structure of the parliamentary system. That parliament, number one, the parliament has the power to make any amendment into the fundamental rights. Number second was up to what extent they can make changes and make amendment into those laws. Before that, there were several other cases were heard in Supreme Court, and the judgment came in favor of people, like Google North case and bank nationalization case, and also there were some other cases wherein Supreme Court wanted to have more power than parliamentary system. So there was a kind of struggle of powers between these two institutions, the parliament and the Supreme Court. At one time, the parliament was saying it has an ultimate power under Article 368, gives its power to make any change in the fundamental rights, and then later on they came up with certain amendments, 24th, 25th and 29th, which is all about fundamental rights, the right to property and reforms of the land. So these three amendments were also challenged in 1973 when the judgment came after several years. At first stage, Supreme Court said yes, that the Parliament has the power, ultimate power, to make any amendment into the provision of Constitution, but there is an extent. It should not be interfering into the basic structure doctrine, the basic and the very, I would say, the fundamental right, like a right to freedom of speech, to certain extent, freedom to religion, practice the religion, and a place of worship and all those stuff. The very basic fundamental rights, equality to the law and all that stuff were discussed, and the judgment came into favor for this Kesavananda Bharati, who was the head of this premises called Endimir Mutt. So later on, the Supreme Court has also laid down certain features, which I'm just going to talk about. There were the multiple things which were laid down. The preamble also became the part of Constitution. The supremacy of the Constitution, republic, democratic form of the government, secular character of the Constitution. Secular character of the Constitution means that the state or the center will not have its own religion. They will never be making any decision. They will never become biased on terms of religiosity of an individual. A state will not have its own religion. Separation of powers between legislature, Supreme Court, executive and judiciary. Federal character of the Constitution. What is this federal character? It means there are some powers given to the state and there is some power given to the center. There is equality in certain aspect. And later on, some more features were added by the Supreme Court from time to time as the basic features, such as power to review by the court, dignity of individual and right to livelihood, Right to freedom of religion. Right to freedom of religion is one of the major component of these doctrine, basic doctrine feature. Right to freedom of religion, right to freedom of acquiring a property, right to property. These are the things, very basic features of these judgments. However, the list may be longer, but it may not be constricted. Thus, the preamble read, with these provisions of the Constitution, lays down the basic norms of the Constitution of India. Sometimes a basic feature may overlap. For example, the concept of secularism is one of the facet, and the right to equality woven into the central golden thread in the fabric, devastating pattern of the scheme of our Constitution. Constitution of a country is called ground norm. That is, the other laws acts as status, rules, regulation emanate from the Constitution or should conform with it, should not be inconsistent with the Constitution.